Welcome, friends. It's good to see all of you again, especially live and in person. Today, we will be discussing what the 2023 state Supreme Court election means to Wisconsinites. I'm Emilio Torre, Executive Director of the Milwaukee Turners, and I'm incredibly excited for today's important forum with our guests, who I'll introduce in just a couple of minutes. Really very proud to welcome you to our first hybrid Phillips forum. We're incredibly excited and a little nervous because we have all sorts of new technology that we're learning to use live. First, today's nonpartisan virtual forum is being hosted by the Milwaukee Turners in partnership with Wisconsin Voices, the Building Unity Coalition, which is comprised of over 40 different groups, as well as the NAACP, Expo, Marquette University Center for Urban Research and Teaching and Outreach, the American Constitution Society, Rid Racism Milwaukee, MICA, the National Lawyers Guild Milwaukee, DeRoot Consulting Cooperative, Unity Racine, and Turning Tables Tavern. Cheston Van Huss is our tech director, Chrissy Fung is our producer and broadcast supervisor, Ryan Finley is our house manager, Gabby Taylor is our second camera operator, and as I mentioned before, we are also assisted by stage managers Juan Arevalo, Darren Madison, Lexi Lee, and fellow Turner Brandon Williford. All right, with that out of the way, and to help us take a deep dive into what the 2023 state Supreme Court election means to us, we have four great panelists. We have them also because the only candidate to accept the invitation to come in person to this forum was Judge Everett Mitchell. But in order to be fair and nonpartisan, we arranged to have this brilliant panel of scholars and experts shine a light on the incredibly important issues facing us for the Tuesday, February 21st primary and the Tuesday, April 4th election. Joining us here today are Craig Mastantuono from the American Constitution Society, Elizabeth Pierson from Law Forward, Matt Rothschild, formerly of the Wisconsin Democracy Campaign, and Michelle Velasquez, Legal Director of Planned Parenthood. Today we'll be discussing the upcoming Supreme Court election. What's on the line? Why does it matter? And what has recent history shown us? And most importantly, why should we vote? Thank you, everybody, for joining us today. Today's nonpartisan virtual forum is being hosted by the Milwaukee Turners in partnership with Wisconsin Voices, the Building Unity Coalition, and a statewide coalition of over 40 groups, as well as the NAACP, Expo, Marquette University Center for Urban Research, Teaching, and Outreach, the American Constitution Society, Rid Racism Milwaukee, MICA, the National Lawyers Guild Milwaukee, DeRoot Consulting Cooperative, Unity Racine, and Turning Tables Tavern. Cheston Van Huss is our tech director. Chrissy Fung is our producer, broadcast supervisor. Ryan Finley is our house manager. Gabby Taylor, our second camera operator. And as I mentioned before, we are also assisted by stage managers Juan Arevalo, Darren Madison, Lexi Lee, and fellow Turner Brandon Williford. All right, with that out of the way, and to help us take a deep dive into what the 2023 state Supreme Court election means to us, we have four incredible panelists. But I'd like to preface by saying that the only candidate to accept the invitation to come in person to this forum was Judge Everett Mitchell. And thank you. But in order to be nonpartisan, we arranged to have this brilliant panel of scholars and experts shine a light on the incredibly important issues facing us for the Tuesday, February 21st primary and the Tuesday, April 4th election. Craig Mastantuono from the American Constitution Society, Elizabeth Pierson from Law Forward, Matt Rothschild of the Wisconsin Democracy Campaign, and Michelle Velasquez, Legal Director of Planned Parenthood. Today, friends, we'll be discussing the upcoming Supreme Court election. Why does it matter? What's on the line? And what has recent history shown us? And more importantly, why should we vote? So we're going to go in order, and I guess we'll start with Matt, and we'll just work on down the line. And please don't take any longer than 90 seconds. If you just, I'm not just looking at you. If you just explain to the audience who you are and what your group does, that would be fantastic.
Thanks, Emilio, and let's give Emilio a big round of applause for all he does here at Turner Hall. So I'm Matt Rothschild. I'm the executive director at the Wisconsin Democracy Campaign, which since 1995 has been tracking and exposing money, all the big and dark money in our politics here in Wisconsin, and then we advocate for a broad range of pro-democracy reforms like defending voting rights, overturning gerrymandering, etc. So I've been there for 8 years, and the staff's been there for about 25. So.
Hi, everybody. I'm Elizabeth Pierson. I work at Law Forward. Oh, is it not on?
Oh, it might be on. There you go.
Is that better? No?
Real close.
Real close? Like that? Yeah, there you go. Oh boy, okay. Hi, I'm Elizabeth Pierson. I'm an attorney with Law Forward. We're a newer, nonprofit, nonpartisan, pro-democracy law firm based in Madison. Our purpose is to make sure that people can vote and that their votes count and matter. And late last year, we put out a report about the Wisconsin Supreme Court that we call Deconstructing Democracy. It looks at some of the main cases from the 2021 to 22 term and their implications for our democracy in this state. So it's a little long, it's a little wonky. I'll be talking about some of the stuff in that report. It is available on our website if anyone's interested. And on a personal note, I am from Milwaukee, so I'm always thrilled to be back. Thanks so much for having me.
Good afternoon, everybody. My name is Craig Mastantuono. I'm the Milwaukee Lawyer Chapter Director of the American Constitution Society. American Constitution Society, or ACS, is the nation's largest progressive lawyer group. It is a nonpartisan group. It is a grassroots organization organized chapter by chapter in cities and states across America. Russ Feingold, our former senator here in Wisconsin, is the national president.
Give it up for Russ.
Absolutely. And American Constitution Society focuses on many issues related to the legal system, not the least of which is gender, racial, and equity inclusion on our courts, as who sits on our courts, from the Supreme Court, state Supreme Courts to our circuit courts and our federal court benches, reducing mass incarceration, voting rights, women's reproductive rights, and a variety of other issues. Locally, I am a criminal defense attorney, and I am a partner at the firm Mastantuono, Coffey & Thomas. We defend people accused of crime and in crisis in the criminal justice system.
Good afternoon, everyone. My name is Michelle Velasquez. I am the Director of Legal Advocacy and Services for Planned Parenthood of Wisconsin and Planned Parenthood Advocates of Wisconsin. Planned Parenthood Advocates of Wisconsin is a 501c4 organization, but we do a lot of C3 allowable work, including civic engagement, community organizing, and my job specifically right now is really around reproductive health rights in this state. Thank you.
As an aside, Michelle is also on our board of directors and is one of my favorite humans. Not to disparage you, I like all of you. So maybe we should begin by discussing how we talk about Supreme Court candidates. There seems to be a pretense of this being a nonpartisan election. That doesn't seem to be how it's framed for the public, though. And I'm wondering, should we reframe how we talk about this? Is it something we should consider maybe moving towards partisan elections like they did in North Carolina? We don't have to go in any certain order. I know that you may all feel strongly about answering one question or another, but we can open it up and just jump in where you feel like you'd like to jump in.
Well, it's a joke. It's the biggest joke in Madison, actually, that this race is a nonpartisan race, because our politics in Wisconsin have become so hyper-partisan over the last 12 years that every race for almost every office is very partisan, whether it's identified that way or not. And in the previous few Supreme Court races going back a ways, everybody knew who the liberal candidate was and who the conservative candidate was. And it's true this time around, too. So ostensibly it's nonpartisan, but actually it's a partisan contest, and a very important partisan contest. And actually the ideal of having it be nonpartisan is a good one, I think. I mean, the judges and justices we select should not, have a predetermined outcome as to how they're going to vote on every case that comes before them. On the other hand, we elect judges and justices in this state. I believe that's a good thing. I think people should be able to elect the judges and justices who determine our freedoms in many respects in our state. So, this is an opportunity for people to choose who represents them and who represents their values. So I can see both sides of making it partisan or keeping it nonpartisan, and I certainly want to uphold the ideal of impartial justice. But with all the huge money that pours into our state, and there's an article in the Journal Sentinel today about that, the big money on the right and the big money on the progressive side is going to come in, and they know which candidates are on their side. So I think there are some people maybe in the state who still think it's nonpartisan, and I just think we should be real when we're talking to them about where the candidates stand.
Would anybody else like to jump in on that one?
I guess I would just add to the point of why it matters and is a worthwhile goal for it to actually be nonpartisan. The political parties in this state do litigate, and they do wind up in front of the Supreme Court. So although I certainly understand and agree that the nonpartisan races are more theoretical than practical these days, I would definitely agree with Matt that it's a worthwhile goal to have it stay nonpartisan, because we want a Supreme Court that can decide cases that are brought by partisan actors where everybody doesn't immediately assume they know where they're going to come down. And I think once you put a D or an R next to a candidate's name, it just makes that much, much harder, both from a perception point of view, from how people will look at those judges, and from how those judges are going to actually rule.
If I could just add to that, I think that sometimes when we say something is nonpartisan, we kid ourselves into thinking that that's somehow divorced from the issues and values that are important to us and that form our own political beliefs and values and where we stand. I mean, I think that personally, I think if you care about people more than corporations, if you care about the involvement of race in the criminal justice system and whether or not it's fairly reflected in results, I think you tend to be on the progressive side of those issues. And if you tend to be on the progressive side of those issues, you tend to follow democratic politics and participate in democracy that way. And so to say something's not partisan doesn't take away the debate over those values. I think that the challenge of a nonpartisan race, and I think, by the way, we should remain nonpartisan in our Supreme Court races, is that it does add a challenge to the candidates to speak to the issues that we care about. And when the candidates speak to the issues that we care about, and I know you got to filter through all the, I'm not gonna be the dangerous candidate, and I'll talk about that a little later, the way we use crime as a cudgel in these Supreme Court races. But if you filter through that, you really have to listen to what are these candidates running on, rather than just I'm a Democrat or I'm a Republican. So I think it forces them to speak to the values that we care about. And if you're on the conservative side, those are different challenges as well.
Mm-hmm. So maybe hinging off some of that and taking a look historically, the Supreme Court and court elections generally seem to have incredibly low turnouts for voters. Can we address that? Why don't people turn out to vote for judicial candidates?
I've got a quick answer, because they're in April, and they're not during other general election campaigns.
I think that there's a low turnout for whether it's circuit court or Supreme Court races, because people, frankly, I don't think know what the courts do. I don't think they know totally what their role is in shaping our rights and liberties in this state, and really, truly, what is at stake. When you think about how long a justice can sit on a court and how many cases he or she could decide that have, in theory, lifetime impacts, it's pretty astounding, and I think there's a lot of mystery about what the court actually does. It's also nonpartisan, so maybe people aren't feeling as fired up, but I agree wholeheartedly with Craig's response from the last question. So the challenge is really getting people to understand what's at stake in Supreme Court elections and providing a lot of education around the role of the court.
Mm-hmm.
I agree definitely with both those points. And I'd add that the April election doesn't have, at least this year, doesn't have national candidates on it. So that leads to different types of media coverage. I think people who have a lot going on and aren't necessarily avidly following every turn of politics, you get a lot more coverage of these national Senate races and governor races. They're just in the media more, and they're not just in local media, they're in national news. Whereas, this year may be an exception. We are getting some national attention on the Supreme Court race. But in general, these spring races, they just get less attention in that media landscape. I would also say that, voting could be easier. There are countries where Election Day is a holiday or where Election Day is on a weekend. And that's not true here. So folks, for the most part, do have to kind of find a way to fit it in their work day or all of their other responsibilities, caregiving or whatever else they have going on. And certainly we have long hours for voting and there's early voting. But there are definitely things that could be done that might even make it, reduce some of those barriers to voting that people do face.
And I think there's going to be a higher turnout this time around. The issue of abortion is still front and center for a lot of voters. The highly polarized state that we're living in and all the money that's coming in is going to increase voter turnout. I think also there's been an awareness, especially on the progressive side in this state, since Scott Walker, that, you know what, every election's important in this state. I mean, I used to live about near the stadium in Madison with a lot of folks who were concerned about politics, but mostly concerned about, who's going to be president and who's going to be senator. And it became really important who was governor. It became really important who was sitting on the Wisconsin Supreme Court. It became really important who had control of the legislature. And so I think a lot of people over the last 12 years, 13 years here in Wisconsin have woken up to the fact that it's not just who you put in the White House that's important, it's who you put in every office up and down the line. So I just want to encourage everyone to vote. You can vote next week. You can vote Monday through Friday next week. If you don't do it then, make sure you vote by February 21st. If you have an absentee ballot, make sure you get it in the mail Monday or Tuesday or deliver it, hand deliver it to the clerk, drive it over to the clerk's office, and make sure you vote again on April 4th. I mean, this is a crucial election for us here in Wisconsin.
Thank you all. And Craig, you were mentioning something about the importance of folks voting their values. And the vast majority of Wisconsinites support a requirement to conduct a criminal background check prior to all gun sales and an extreme risk protection law which would allow families to petition a court to temporarily remove firearms from loved ones in imminent danger of hurting themselves or others. Could any of you answer what the Supreme Court might be able to do to support or squash these policies that have pulled so strongly with residents?
Well, I mean, if Wisconsin residents support such an enactment and that were to become a law, I'm sure a law like that would be challenged, right? And so the Supreme Court would be the ultimate arbiter on any challenge like that because it would go up to the state Supreme Court. When it gets up there, we're going to have 7 justices, right? And who are those people? And if you have a conservative majority on the Supreme Court, I think that a requirement like that would be in grave jeopardy of survival. There has been the rise, the thing that marks my practice more is as much as the opioid epidemic, which is the other big hallmark of my criminal defense practice of the last 15 years, is also now the proliferation of firearms in all of the cases that I work on in my criminal justice practice. We have exponentiated the amount of guns in our society to a high degree. I've been practicing law 30 years to give you perspective, but the last 10 have become extreme in the proliferation of firearms, so that arguments become fatal incidents, so that road rage becomes disorderly conduct while armed. And so it has really affected the criminal justice system to a high degree and endangered officers and citizens' lives to a higher degree, and also has involved people that I didn't used to represent in the criminal justice system into the criminal justice system for acting like a knucklehead with a firearm. And some of it's not shooting a firearm, some of it is just wielding or being found with a firearm while intoxicated, etc. And part of the reason for that, and I'm going to wind back and try to stick to the 90-second rule here, but part of the reason for that...
90 seconds is only the first one. You guys can pontificate now.
Part of the reason for that is because at the national level, right, the United States Supreme Court decided the Heller case, which made Second Amendment rights an individual right. And since that time, though at the time Justice Scalia, who wrote the majority opinion, noted that no constitutional privilege or right is absolute, Second Amendment rights have kind of been treated as an absolute right since that time, and have reasonable restrictions on firearm possession and firearm acquisition haven't really survived well since then. And there's a large funded movement to support that, largely on the right. So I'm walking it all the way through. How could this election affect something like that? I think the answer is obvious. I mean, if we have a balance in the majority right now, dependent on the next election between, liberal and conservative justices, a law like that is going to be directly affected if challenged, and either, as you say, squashed or ruled unconstitutional as a violation of Second Amendment rights and state privilege, or it will survive depending on the values of those justices voting on such a regulation.
Go ahead.
And I'd like to just take it one step back, which is I think the biggest thing the Supreme Court can do on this issue and lots of issues is fix the map and end the gerrymander. Because what we have right now is a legislature that is not meaningfully accountable to the voters. And so even though huge majorities of Wisconsinites support common sense gun safety regulations and bodily autonomy for women and people that can give birth, we just don't have a legislature that's likely to pass a law like that under the current maps. So depending on what the court looks like, when the maps get challenged again, the outcome could be very different. And if we could actually fix that gerrymander and get fair maps, that's when you get to a point where Wisconsinites can actually elect representatives who are going to govern on their behalf in Madison and pass laws like that that have the support of people in this state.
And let's remember, these maps were rigged in 2011 by Walker and the Republicans, and they were rigged again by Voss and the Republicans this time around. And then they were ultimately rubber stamped by a 4-3 conservative majority at the Wisconsin Supreme Court. So it really matters who's on that Wisconsin Supreme Court if we're going to have any ability whatsoever to throw out these rigged maps and force the legislature either to redraw fairer maps or have the court appoint someone who can draw those maps themselves and give us better representation, fairer representation here. So the gerrymandering issue is one of the big issues why people should turn out and vote in this Supreme Court race.
Thank you so much, friends. And I should have prefaced all of this by saying I am not the brilliant person who came up with these questions. We have almost 800 card-carrying Milwaukee Turner members, as well as all the great folks in the coalitions. And these questions were submitted by them to us. So these are actually questions that you all in the audience and other folks wanted to know. And that's what makes this forum and your answers so much more important. So recent court decisions have reduced voters' access to drop boxes for depositing ballots in Wisconsin. Do you believe that voting rights should be restricted in this way? And can you explain maybe what the state constitution's orientation to voting rights is? So this was a question originally directed towards Supreme Court candidates, but if we modify this for how we're interpreting it, let's just skip the second part. What can be done, or can anything be done by the Supreme Court to increase drop boxes for depositing ballots in Wisconsin? I mean, certainly over the past 2 years, it's become a lot more arduous for voters to be able to cast their votes with restrictions on time and place, taking a look at motor voter, quashing the motor voter. Are there ways that the Supreme Court can affect or ameliorate our process, which seems to be one of the most fundamental processes of a democracy, and certainly for Wisconsin eligible voters? Is there some way that the Supreme Court can affect this, make it better, or God forbid, make it worse?
I should probably take this because Law Forward litigated that case with the drop boxes. And I will back up to the first part of your question. We don't think the court got it right. Law Forward represented Disability Rights Wisconsin, Wisconsin Voices for Justice, and the League of Women Voters in trying to explain to the Supreme Court why they should not place more barriers in the way of people casting absentee ballots. And the court did not see it our way, and they did create those barriers. In fact, they ruled in such a way that it became impossible for certain disabled voters to cast ballots at all because clerks were interpreting their decision in a certain way that said you must personally return your ballot. So we actually had to go to federal court to fix that, which we did. Disabled voters do have a court-enforced and constitutional right to vote in the way that they need to vote.
Could you say that again louder for the crowd in the back?
Disabled voters in Wisconsin do, of course, have a protected right to vote. It's protected by federal law and by the Constitution. It's a shame that we had to go to federal court to get that affirmed because of a decision by the Wisconsin Supreme Court, but that is how it shook out. In terms of your other question, I mean, the Wisconsin Supreme Court, just on a very basic level, it hears cases that were brought in lower courts for the most part. People do occasionally bring original actions at the Wisconsin Supreme Court. That's quite rare. So how the Supreme Court would continue to affect voting rights is really going to depend on what laws are passed in the legislature and what kinds of challenges are brought in the courts below that end up at the court. I know it's a vague answer, but that's what I got.
Thank you.
I'm going to just jump in here a second and just elaborate on that horrible Wisconsin Supreme Court case in the case that Elizabeth's firm Law Forward brought. And they banned drop boxes and they banned assistance in the delivery of a ballot. That got overturned for voters with disabilities, as Elizabeth said. But right now it's so absurd. My wife and I got our absentee ballots in the mail the other day. We're going to complete them on Monday morning at the dining room table. And if I took my absentee ballot and her absentee ballot and put it in our mailbox, her absentee ballot could be thrown out if someone saw me put hers in there, because the law states that the individual who fills out the absentee ballot has to be the person who puts that ballot into the mail stream. And so it's just absurd. You can't deliver for, your partner their absentee ballot. Or if I took both absentee ballots to the clerk, that wouldn't be allowed either. She has to be there handing it to the clerk too. So there's an absurd level in the argument that was brought by Wisconsin Institute for Law and Liberty, which the right-wing law firm that totally disregarded the rights of persons with disabilities on that issue, and finally got overturned by our federal court judge Pierson in Dane County. But look, voting rights is crucial. One of the things that concerns me so much about this Wisconsin Supreme Court race is not 2023, but 2024. What's going to happen in November 2024 if there's a dispute here on our electoral college votes? Let's remember, 3 of the arch-conservative justices on the Wisconsin Supreme Court in the case Trump versus Wisconsin were perfectly willing to toss out tens of thousands of legally cast votes here in Milwaukee County and in Dane County and essentially just hand Wisconsin over to Trump. So it really matters who's on that court.
I'd just like to add, just kind of going back to what Elizabeth said, and the question at a fundamental level, like what could the Supreme Court do, or how could the Supreme Court affect voting rights? This really all goes back to the values of the individual candidates and understanding where their values are at, their judicial philosophies, how they view the law. Everyone sort of can say, well, I will, be a fair arbiter of the law, but what does that mean? So I do think it's really important to assess the values of each individual candidate to see where they lie on these really important issues.
Thank you all. And there's certainly truly terrifying consequences that we reaped from that previous suit. Speaking of terrifying consequences, what steps might the Supreme Court take to develop a judicial opinion on the 1849 law restricting abortion access in Wisconsin should a case involving the law come before the court?
Well, I will take that one, I think. So there is a case right now pending challenging the enforceability of that 1849 law. That case has been pending in Dane County Circuit Court since June, and that was filed by the Attorney General's office. A group of 3 physicians moved to intervene, and so there's a second plaintiff in that case. 3 physicians intervened in November. And it is highly likely that that case will end up in the Wisconsin Supreme Court sometime, maybe later this, as early as, sort of maybe fall of this year, just sort of depending on the speed at which the decision in Dane County happens and then where things go in the Court of Appeals, because undoubtedly the losing party will file a notice of appeal in that case. And so at some point, the Wisconsin Supreme Court will decide that case. However, that case only brings the issue of the 1849 ban in sort of one context, which is a statutory construction. Basically, the arguments in the Attorney General's case are that the 1849 law and the newer enacted laws post-Roe that the various Wisconsin legislatures enacted conflict with one another. And so you can't have conflicting statutes, so the newer statutes should win. That's the sort of the gist of it. But that's not the only argument that could be brought challenging that 1849 law. The trends across the country post-Dobbs in terms of state challenges have really been state constitutional challenges. So many states have brought actions arguing that their state constitutions protect a person who can give birth's right to choose an abortion in the scope of reproductive health care. So some states are protecting it in their constitution, some have not. One of our neighbors, Iowa, had a state Supreme Court decision finding that the Iowa Constitution, in fact, did protect abortion rights. Then they overturned themselves a few years later. So now there's still abortion access in Iowa, but it's susceptible again to being legislated in various ways depending on the sway of their state legislature. So my point is that not only will this current lawsuit end up before the Wisconsin Supreme Court, but very likely other types of challenges will also end up before the Wisconsin Supreme Court.
Thank you. Anyone like to add anything to that? Or authoritatively stated? So recently the U.S. Supreme Court issued a ruling diminishing the EPA's ability to implement key provisions of the Clean Power Plan that aim to shift the nation away from a reliance on fossil fuel for utilities and power generators in favor of renewable alternatives. Although the decision pertains to federal regulations, without federal mandates, the Wisconsin DNR may be limited in its capacity to address environmental concerns in the state. In Wisconsin, what protections in law and regulation are available to address threats to the environment from wetland destruction and air and water pollution due to pipelines and coal-fired power plant operation, or PFAS, which we heard a lot of in the governor's State of the State, and as which we also hear from two of the most egregious polluters, the coal-firing plants right over here in Oak Creek. That's a lob.
Well, I think a lot of environmental issues are going to come to the court. And look, one of the most powerful spenders on Wisconsin Supreme Court races since 2005 has been Wisconsin Manufacturers and Commerce, which is the big business lobby in Madison, which has spent $28 million since 2010 to elect Republicans to the governor's office and the state legislature and the Wisconsin Supreme Court. So, and they're very active at the Wisconsin Supreme Court filing briefs. And it's very rare, I think, I don't know of a single case where a justice who's gotten money from Wisconsin Manufacturers and Commerce has recused themselves, in part because there's been an attempt to get a tighter recusal conflict of interest rule before the Wisconsin Supreme Court. League of Women Voters put one up, 54 retired judges put one up a while ago. Those were rejected, and instead the Wisconsin Supreme Court has a recusal rule, which isn't a rule at all, because basically it says it's up to a judge or a justice to decide for himself or herself whether to get off a case or not. That rule was written by lawyers for Wisconsin Manufacturers and Commerce and the Wisconsin Realtors Association. They're the ones who have immense power in the court, hidden power in the court, and they will defend the polluters. So the idea that the polluters are going to be restrained by a Wisconsin Supreme Court if that court is dominated by justices who get funding from Wisconsin Manufacturers and Commerce, well, we're just, we're kidding ourselves on that.
Just elevating that to a big picture perspective, as it relates to Supreme Court races. You mentioned Wisconsin Manufacturers and Commerce, and we're talking about environmental regulation. Look, this is the big prize, okay? The real game that's being played behind the game is big money behind big corporations wanting less government so they can do what they want in our society unfettered by something like government and government regulations by regulatory agencies. And every time you have one of these Supreme Court elections, the way that's interpreted or to the voters is through my practice specialty, criminal justice. Wisconsin Manufacturers and Commerce and others fund commercials trying to scare the heck out of Wisconsin voters. Often Willie Horton racist-style ads about black men coming to get you because some candidate did something in their case that resulted in a tragedy in the criminal justice system. And I got news for you. Those big businesses that are funding those commercials don't give a hoot about your public safety or that particular case. They're just trying to get to the prize, which is electing justices that will not interfere with the ability of big business to pollute or make money unfettered by government regulations. And that's, the real kind of litigation body of law that's creeping up. When you hear things like deep state, okay, and regulatory agencies, what they're really talking about is agencies like the EPA, both as it relates to interpreting standards that are passed by legislative bodies like Congress and the state legislature, and also just the very existence of those agencies themselves, and they're attacking laws that regulate business in ways that interfere with corporations' ability to make money. And it drives me crazy that it dips into my practice and affects my practice, frankly, to a high degree because of this tough on crime stuff that you see running, attack ads on both sides. And it works on the progressive side too. It's no coincidence that, prosecutors are seen as attractive candidates for progressive candidates to the Supreme Court rather than people that represent people accused of crime. I mean, somebody like myself could never run for Supreme Court because I've represented people that have committed crimes in our society rather than put them away. People want lawyers when their loved one, son, daughter, spouse is in trouble, but in the concept as a whole, somebody that represents people accused of crime could never run for Supreme Court. So the real prize, though, is deregulation. And we use things like crime, criminal justice, and scaring people as a way to get there. And it often has an ugly racial component to it that's just not acceptable, in my opinion, in an organized democracy.
Let me just jump on that for a second, because we all saw the hideously racist ads in the last campaign against Mandela Barnes. These ads were run by Ron Johnson himself in his own campaign, and they were funded by almost $30 million from a misnamed PAC called the Wisconsin Truth PAC, which was founded and funded by two billionaires, one in Wisconsin, Diane Hendricks, who runs ABC Supply in Beloit, and the other, Richard Uihlein, who lives in Lake Forest, Illinois, of all places, but runs the Uihlein Corporation with his wife. They poured all this money into these hideously racist ads, and they had a horrible effect on the election. So I totally agree with Craig on that. I also agree with Craig on the prize. Big business knows that they can maximize profits for their members pretty cheaply by funding their people for Wisconsin Supreme Court or for governor or for the legislature. Because there are only two things that get in the way of corporate predations and maximizing profits at the cost of labor rights and the environment and consumer rights. The only two things that can get in the way are, one, Craig mentioned it, government regulation. The only other thing, labor unions. That's why Scott Walker went after the labor unions. So this is part of a concerted far-right effort funded by far-right corporations and foundations, the Koch brothers and people like that, for the last 50 years to take over every level of government and to decimate the unions so that corporations can, laugh all the way to the bank.
Can I build on that?
Please.
I'd like to do a little Schoolhouse Rock. Just getting back to what can our Supreme Court do around environmental regulations. I'm not an environmental lawyer, but just taking a step back. In Wisconsin, we have the three branches of government that we all learned in school are supposed to check and balance each other and kind of together run the government for the people of Wisconsin, right? And traditionally, the executive branch, so that's the governor, and the administrative agencies under his purview do a lot in environmental regulation, as well as other areas. But you think of the DNR, the Department of Natural Resources, trying to kind of regulate in this area. The legislature also has a role to play. It passes laws, but we rely on agencies which are staffed by subject matter experts who are also accountable to both the governor and to the legislature to kind of implement laws and regulate and do things that make sense for the people of Wisconsin. What we've seen in the last few years is that the legislature has been kind of gathering more and more power unto itself, and the court has been greenlighting that. And in case after case, and we go into this in detail in our report, but in case after case, we've seen the court side with the legislature and side against Governor Evers or his agencies in ways that really unbalance our government and that have made it harder often for agencies to do their jobs. One, I think, obvious example that was in the news a lot was when Fred Prane refused to step down from the DNR board. This was a Walker appointee whose term expired in May of 2021. So it should have been Governor Evers' turn to appoint somebody to that board. And Dr. Prane refused to step down. And that went all the way to the Supreme Court. Josh Kaul sued to have him removed. And the court said, we're just going to let him stay. So that's kind of hobbling the ability of the duly elected governor of the people of the state of Wisconsin to run this agency according to his values and according to the agenda that Wisconsin voters voted for. And just another element of these aspects of racial justice that are really underlying a lot of these issues, you look at the coalition that elected Governor Evers, and it does include a lot of black voters and voters of color, as well as young voters who tend to be more interested in environmental issues. So we've really seen the court make decisions in ways that kind of disrespect and undervalue certain voters and make it more difficult for government to be accountable to them while empowering the legislature to kind of do what it wants.
I love this, and thank you for those answers. I think to all the viewers here, as well as myself, just seeing you connect, the three of you connecting the dots to how and why this is important, how folks are trying to deregulate and almost rubber stamp what would apparently to any of us seem to be an illegal practice of keeping your job after the job is terminated just because this referee is not going to hold up the yellow card or red card to whoever commits the foul. When folks talk about conspiracy and they talk about issues about it's just a judge, I don't know what that matters to me. This is a classic example of how big money interests are affecting the lives of all the millions of residents in the state, potentially opening up to opportunities of not only racial and economic exploitation, but potential cancer behind the exposure to these toxic elements. And it's done in such a way as to obfuscate the issue, hide it from the average voter, put it behind the scenes, and create exactly what you just said, Craig, like almost a deep state issue where folks are given talking points to say, oh, it's deep state, and they don't understand the issues about how it's directly going to affect them and their loved ones' health.
Well, until they need the DNR to come out and correct a problem at their property or they're affected by it. Then everybody wants, a government actor and is wondering, where's the government?
Yeah.
I have a problem.
You already
now.
hobbled it.
Right.
Thank you so much. It brings me to another big issue, which I think the four of you are elevating nicely. Due to the extreme partisanship prevalent in our country, but especially I have found as an adopted Wisconsinite. Everyone can tell from my accent I grew up in New York. And so in Wisconsin, so prevalent in our country, and not always by choice, the judiciary is called on to settle issues that seem to be more appropriately decided by policies adopted through legislative action. And this is a two-way street because it seems that they're punting things too to the legislation. Somebody's parking meter is up. This usually results in cries of judicial activism. And you hear both sides banding about, oh, they're judicial activists, you can't vote for them. What are real examples of judicial activism and how does that occur and why? What should we really be on the lookout for as opposed to just this dog whistle that seems to be everywhere?
Well, I think Michelle's got the best answer for judicial activism at the U.S. Supreme Court anyway.
Just a case called Dobbs this summer that overturned 50 years of precedent. Roe was decided in 1973. There were a line of cases that came before it discussing these substantive due process rights of privacy. Many cases that came after it relying on that idea of a right to privacy in your family matters, in your personal life, who you marry, what kind of reproductive health care you choose, et cetera. And that all came crashing down with one U.S. Supreme Court decision. But that was not just kind of a random act. It was nearly 50 years of really careful strategy by people bent, on undoing Roe. And So it was very, very strategic, and part of that strategy was making sure that the right judges were, whether they needed to be elected or appointed, received those spots in state and federal courts so that they could bring the cases that they needed to bring up to those judges to kind of slowly chip away and erode these rights. And so that strategy was fulfilled in this past June in Dobbs. That is not the end game for folks who really would like to see a national abortion ban. And so it's sort of underscores again the need for people to really understand the role of the courts and how significant of a role the courts play in their daily lives and the rights that they enjoy, and how judges get to those spots. So in federal, federal courts, those are lifetime appointments. So when a president appoints a federal judge, that person has a job basically forever. And there are some really, really problematic cases in reproductive health care happening right now in the Northern District of Texas, a federal court there. That judge was appointed in 2019 with the former administration. And people are, again, sort of cherry picking their court to bring these cases to. And so, Wisconsin, of course, doesn't, when we do have appointments, when there are vacancies, that's important to know. But Supreme Court justices are typically elected. And so there is a turnover after 10 years, but it's usually hard to unseat an incumbent. So that's, probably the biggest example of judicial activism I can think of.
Mm-hmm. Huge one. I've got an example from the Wisconsin Supreme Court. Goes back to the gerrymandering case. This time around, the court was looking at the map that Voss produced and the map that Evers produced initially. And then it came up with, out of thin air, instructions for drawing another map. And it said you should take an approach that is the least change approach to the 2011 maps. And the 2011 maps were horribly rigged by Walker and the Republicans. There's nothing in the Constitution or in statute that mentions least change, or in practice by other states when they're redrawing the maps. Our state constitution says you need to draw anew or redraw the maps after every census. It doesn't say you go back to the last maps, whether they were rigged or not, and adapt from there with the least change possible. So it was a total act of brazen partisan judicial activism right there.
Just doing a little more kind of on a Schoolhouse Rock motif as it relates to constitutional rights and the law. I mean, judicial activism, okay, and branding one kind of side, liberal versus conservative, or the other with that tag is just, it's a straw man argument. It's a false argument. Look, our courts of review, our state Supreme Courts and the United States Supreme Court, are there to interpret state and federal constitution. And when laws are challenged, it's the role and the appropriate role of Supreme Courts to determine whether laws conflict with people's rights under the state and federal constitutions. And so good examples of judicial activism as that tag is applied are Brown versus Board of Education and Loving versus Virginia, right? Where you had laws that allowed, segregated schools and outlawed interracial marriage. And those laws were challenged. That was an active role in challenging those laws. And they produced decisions where the United States Supreme Court said education shouldn't be segregated and there shouldn't be a ban on interracial marriage. And those were what I think we generally think of as good outcomes in our society that furthered democracy. Examples of judicial activism on the conservative side would be certainly the Dobbs decision that Michelle just talked about. You had activists challenging precedent, not precedent this time, not an existing law, but through challenging laws in the various states as the result of the Roe v. Wade decision, or the Heller case that I spoke about earlier, which was a challenge to a Washington, D.C. regulation on firearm possession. And in those cases, you had activists challenging either existing precedent and laws or a law. And then what you see is on the conservative side, the claim of, well, we're not judicial activists. We want the law as written, not as we'd like it to be. Well, not when it applies to a reasonable firearm regulation, right? Not when it applies to laws that are enacted as a result of Roe v. Wade, a 50-year precedent, honoring women's reproductive rights. And so, it's just a facade, right? You have to look what's behind the argument. And saying I'm an activist or I'm an originalist or not, you know what? All of these candidates have values. Their values are informed by their institutional positions, their politics. They're no different than any of us. And what you really have to decide is what side do you stand on? And what side do these justices stand on? Do we want desegregated schools and society? Do we want to outlaw bans on interracial marriage? Do we want to honor women's reproductive rights? Do we want reasonable firearm restrictions? Who are those people? And let's put the judicial activism tags aside.
I mean, part of it is, are they curtailing our freedom or are they expanding our freedom? I mean, that's one way to look at it. And there was a Wisconsin Supreme Court case. I'm going to go into your corner here, Craig. A defendant's privacy right case. This was in 2016, a case called State of Wisconsin versus Richard Weber. Yeah. The guy's driving home. He's 100 feet from his house. There's a cop behind him who puts on his siren. The guy drives into his attached garage. Yeah. The cop demands that he come out. Instead, he goes into his house. The cop follows him into his house, tells him to come outside, finds that he was drunk, arrests him for being drunk, searches his car, finds a marijuana and a pipe in his car. He gets convicted. He appeals, saying my right to privacy and being safe and secure in my home has been violated. Wisconsin Supreme Court, 4-3, including with Kelly on it, said no, it was an okay search. It was a legal search. Yeah. I mean, it's just outrageous. This is, decisions by the Wisconsin Supreme Court affect us in all aspects of our lives, but this is one where, your freedom to be safe and secure in your own garage that's attached to your house, which is a pretty basic freedom, was curtailed.
Yeah, absolutely. I love that you're talking about the Weber case.
Yeah.
Yeah, this going sort of a little bit back to what Craig said earlier. The Fourth Amendment is a constitutional right that I think is not really subject to being so absolute as the Second Amendment.
At all. Yeah, absolutely. We'll talk about that a little bit more. We'll wind that into some more questions.
All right, that sounds good.
Yeah.
So another question, and we've been getting great questions from the audience. Thank you. Just to announce, you can frame things in way of question. We're not going to have the mic go wild out of control around the audience, so please feel free to submit a question on an index card so that we can curate them and ask them. And those of you that are watching on Zoom and on Facebook Live, feel free to share questions in the chat, and we'll see if we can't get them to our panelists in a little bit. So a local legislator has told us that he believes a medical professional should not be obligated to treat a patient who is identifies as a member of the LGBTQIA community if their religious beliefs oppose homosexuality. He clarified that a medical person's religious rights should take precedent over the patient's human rights. What should the court's approach be toward a case where a person's human rights are in question based on their sexuality?
Can I just say real quick, and I want to hear from my fellow panelists, but to set up the answer to that question, the way that would arrive before the U.S. Supreme Court, it would be through a conservative act of judicial activism, because there will be an effort to acquire a plaintiff, right, who has that religious belief and is a healthcare provider, saying, I choose not to provide services to this individual. That will get reviewed and go on up. Am I wrong about that, or is that the way a case like that would arrive?
That sounds right to me.
Yep, that sounds right.
And could you and I agree that that's probably how that would be punted up to get to the Supreme Court. Could you explain to the audience too how that happens? Because I think a lot of people believe court cases happen happenstance, and we all know that that's not true.
No, it's not. It's not true. Look, you. Sometimes they do, right? Like Clarence Earl Gideon, right? Actually, wrote from the jail, I don't have the right to assistance of counsel. I think the Constitution, provides me that. And, on that pro se basis arose, the Gideon decision and Sixth Amendment rights honored first in our federal courts and ultimately through incorporation in our state courts. Mm-hmm. So that's a fun and nice tale in constitutional jurisprudence.
I see them all Googling.
Right. But issue advocacy produces challenges, plaintiffs, organizations that think that the law as it stands shouldn't be. And, we've really funded to a higher degree in recent decades all types of judicial activism on both sides of the aisle, if you will. I don't know if activism is the right but activity, right? And so, recently you've seen a lot more on the conservative side activism in terms of acquiring plaintiffs, like the high school football coach that wanted to take a knee with his players after a public high school game that was the result of a Supreme Court decision last year, or the wedding cake people that don't want to, the bakers that don't want to provide a wedding cake to a gay or LGBTQ community couple, right? These are acquired plaintiffs, right? They're planned out, and people that are challenging their right to be, kind of economically free or free in our society to disqualify people from services that they're providing. And so, that happens. That's funded. Lawyers are paid for. The goal is to get to the Supreme Court. And more, it seems like, they're fired up culture wars that are reflected in this litigation, where I personally, I would argue that desegregating public schools was not a culture war, that it was a war for justice, right, and equity in our society. But a lot of the litigation that you see now, honestly, is this affecting your life? It's affecting certainly the people that are discriminated against by those healthcare providers or those people providing services that choose to discriminate. But this isn't affecting cultural life in America on a large degree that I think we need to be litigating through. But it fires people up, and it affects their politics, and it keeps this politics of grievance, I think, that you see on the extreme right fueled.
And Wisconsin Institute for Law and Liberty is just, in full throttle and picking up plaintiffs that they can go to court. And they're funded by a lot of right-wing foundations, Bradley Foundation and other groups that, keep them busy.
Yeah, I can expand a little bit on that last point that Craig said about, is this really harming you? One case that we looked at from last term at the Supreme Court, at the Wisconsin Supreme Court, was the John Doe versus Madison Metropolitan School District case. And that was some parents represented by Will in the Madison School District suing over a policy that had to do with students' gender expression and just generally gender and sexuality policy that the school had. And Law Forward was not involved in this case, so forgive me if I get any details wrong, but I believe what happened is the plaintiffs told the trial court that they wished to proceed completely anonymously. And the court said, okay, fine, you'll be publicly anonymous, but you have to tell me and you have to tell the other lawyers who you are so that they can prepare the case, because we have an adversarial legal system and you need to know who you're arguing with. And they didn't want to do that, so they appealed it all the way to the Wisconsin Supreme Court, which did 4-3 decide correctly that they were going to have to disclose their identities just to the school district that they were litigating against. Their privacy interests absolutely protected them from public disclosure, but for the sake of having a functional lawsuit, they had to say who they were. And once that happened, most of them dropped out of the case. And I believe one remained, and then that case was dismissed because the judge said that person didn't have standing, which is a judgy way of saying nothing had happened to them, nothing bad had happened to them. So I think that case is just a really interesting example of these types of really like issue-driven lawsuits that are really just trying to like change both the structure of how we litigate, as well as in this case how our public schools work, and then also the tremendous impact that our Supreme Court can have on that, where by a difference of one vote, they could have allowed this lawsuit to go forward in this really unprecedented way. There was no precedent for that. There's never. You can't just be a secret plaintiff to everyone in a case. That's not a thing.
That's right.
Secret Plaintiff sounds like an interesting Netflix show. And some of these answers, I think, to draw attention to the excellent report that Law Forward did, a lot of these seem to be encapsulated by your broader topics of results-oriented judging and direct attacks on democracy, too. And I just want to draw, again, attention to all of you sitting here in person, as well as those of you watching across the state, to take a look at Law Forward's incredible document examining how the Wisconsin Supreme Court spent its 2021 to 2022 time kind of dismantling a lot of our democracy, right?
Thanks, Emilio, yeah.
You owe me $10. No. So, it is no secret to anyone here, or any of the folks watching, really, that Wisconsin, the United States, is one of the most atrocious nations on the planet for how we incarcerate human beings. We are in bold Sharpie marker racist and classist in our practices, and Wisconsin has grotesquely and wrongfully abused generations of black and indigenous residents' generational wealth, incarcerating whole scale. Milwaukee County, Dane County, Rock County, choose a county. The statistics are grotesque in how, especially statistically black and Native men, but also black and Native children and women, have been arrested, stopped, detained, given disproportionate and grotesque sentences behind this stuff. Full disclosure, the Milwaukee Turners are committed to confronting mass incarceration, have been for a long period of time. And we have a series of questions on this, and I want to kind of synthesize some of them because not all of them are going to make it up to the Supreme Court in the way these things do. And there are a lot of brilliant questions we're getting, but we're trying to keep this forum, and we do have lots of forums, relevant to the state Supreme Court. Are there ways that the state Supreme Court might positively impact our demonstrably broken criminal legal system? And I don't know if this plays into ways that we can restore the right to vote to folks living with criminal convictions in the way that other states have. If there are other ways that the four of you might see that the Supreme Court might somehow be a release valve for this incredible pressure of evil that we have done to men and women and children in our name in this state.
Can I just kind of set the question up a little bit more with some statistics
I was
about
feeling the Holy Spirit.
Wisconsin? So many of in our audience and members of the public are aware of the UWM, University of Wisconsin-Milwaukee study that came out shortly after the 2010 census, which was a study that started out as a labor study, but the researchers kind of wandered into realizing that Wisconsin was incarcerating black men at an incredibly high rate, and it was interfering with their ability to work. And that's how the study became formulated. And what came out of that study was that Wisconsin led the nation. And what this part isn't usually added, was an outlier in leading the nation in incarcerating black men. We're the #1 state in the country at locking up black men in prison. And just to give you an idea of the numbers, Wisconsin was locking up working age black men at a 12.8% rate. And the next closest state was Oklahoma, which was several points down, I think in the 8-something.
6.3?
And the national average was 6.7.
Oh.
So we really were an outlier. I want to draw your attention to another study that you might not be as aware of. So write this down if you're listening and look it up and Google it. It's the Sentencing Project. The report is called The Color of Justice. That came out in 2021. Okay, and was an update to the data that we are aware of. And sadly, as a criminal justice practitioner in the state of Wisconsin, this is a title I do not want to hold for our state, that I don't want our state to hold, right? And we are still #1. We are still #1 at locking up black men in this country, okay? So that is our criminal justice system right now in our state. That's what we are producing, all right? And so as a lawyer who was taught that, the law is blind, this image of Lady Justice with the blindfold on, I think it really inhibits our having real conversations about the fact that we are turning out an unfair and broken product in our criminal justice system. There's no way that you can defend a system that has an outcome like that, and all lawyers, prosecutors, judges, defense attorneys, legislators, we wring our hands, okay? And most of the professionals in the criminal justice system say, well, there's nothing to be done. Every case is individual. We look at every case individual, and justice is blind, and we have to stop that. The first thing we have to do is stop and say, justice is not blind. Justice is producing an outcome that we should not be blind to. There's something broke. What can we do? And so the Supreme Court can set that tone as the leaders of our judicial system from the top down and admit that there is a problem rather than trying to ignore it. That's what I would set up as the premise for this question.
I also think at some point the Wisconsin Supreme Court could and should address the issue of extended supervision, parole, and probation that is so extreme. And there are people who are being reincarcerated, not because they're committing a crime, but because they are violating some petty little probation issue. And I also think we got to look at the issue of reenfranchising persons who used to be incarcerated. There are 46,000 people in Wisconsin who've served their time, paid their dues back to the community, are living in the community now and being productive citizens, and their citizenship rights to vote aren't being validated. And actually, there's a horrible bill in the legislature sponsored by a couple of Republican legislators right now to make it harder for them to get off extended supervision. Right. That they'd have to pay off every single court cost that they ever incurred before they could get to vote. So, this is an ongoing problem that could get worse, actually.
At the risk of repeating myself, the gerrymander is important here, too. Again, if the court were to fix the maps, and if we could get a more accountable state legislature, I think we'd be seeing different types of laws coming out in all types of areas.
Prison gerrymandering is an issue, too, that the court could address. Now, prison gerrymandering, this is what happens if you're in Milwaukee and you commit a crime, or you're convicted of committing a crime, whether you committed it or not, and you're sent up to Waupun, you're counted as living in Waupun. And you're counting there, if you were there in January of 2021, you're counted as living in Waupun for the next 10 years, even though you're back in Milwaukee a year and a half later. And as a consequence, Waupun gets more representation and more resources, and Milwaukee County gets less representation and less resources. And a lot of states are getting rid of prison gerrymandering, either legislatively or judicially, and our court could do that if it was constituted a little better.
Another huge way to impact this, an issue that American Constitution Society has been working on, is diversity on our benches. Who's making the decisions that affect people in our community? Does our bench look like the community that it serves? It hasn't in Milwaukee County, Dane County, or across the state. And the current governor is appointing judges in vacancies when they become open in a way that reflects gender, racial, ethnic, practice, diversity among the lawyers that he's appointing to the bench. When judges look and reflect the communities that they serve, you will inevitably arrive over the long term at more equity in our criminal justice system, and that's important.
I'll just add a little bit, just a little bit back to something that Craig mentioned about how the Wisconsin Supreme Court could really start looking at things through the lens of there is a problem. This is not okay. Our system is broken. Justice is not blind. And so if they come at cases that go before it with that lens, there will be much more, I would hope, scrutiny in challenges to, for example, the length of a sentence. Did that judge properly apply the case law that requires there to be a nexus between the number of years and the need to protect the public, or whatever they decided the sentence, whatever they decided the objective of the sentence was. There are cases that tell our courts how to sentence people, what constitutes ineffective assistance of counsel, when the Fourth Amendment has been violated, but I don't think they're always scrutinized through this lens of there's a problem here. We should be really, really looking at each case and thinking, did that circuit court judge properly sentence this person, and not just rubber stamping and assuming that they've done everything properly.
And that's in a state, by the way, where we give our judges incredible discretion to do essentially whatever they feel is right in terms of incarceration, 0 to 10 years, 0 to 20 years, whatever the maximum penalties are. And those decisions aren't scrutinized. And look, the way this breaks down is in any system, right, where you have the ability to negatively impact people, and then you have a society that is affected in many ways by race and the lens with which we view people. People of color are always going to be disparately impacted to a higher degree than their similarly situated counterparts who are not people of color in the criminal justice system. We have overall an overly oppressive criminal justice system in our country. People of color are just paying twice as much in an already expensive system, right? And it's impacting people. I will tell you, the first 7 years of my career was as a public defender. and the last 23 have been as a private attorney. As a public defender, I learned really quick about race and criminal justice when I walked into a bullpen for the first time, people who are held in custody while their cases are pending, and saw 20 black and brown men, and not one white person in the holding cell. Okay, these are the people that have cash bail imposed, usually in low amounts, and can't afford to get out. And when they go for sentencing in front of a judge, they're wearing an orange jumpsuit, okay? And, frankly, the culture in that room typically was, well, you're a person of color and you acted in conformity with how I see you, in conformity with your race. And frankly, as a young lawyer, when I was representing Johnny from the suburbs, whose parents got him out of jail and went to court in his Sunday suit, right? The culture in that room is, gosh, what a shame. You've had so much opportunity, and this case is really impacting your potential to make somebody of ourselves. And it's the saddest thing to me that we don't see those two young men as equals with equal opportunity and equal ability to be pro-social in our society. And this is what we have to stop doing in our criminal justice system. So let's have a real conversation about race in our criminal justice system instead of paying attention to these commercials about who's standing up for victims or who's keeping you safe in a Supreme Court race, because that's not what's going to be the outcome of this race. Let's have real leadership.
Thank you for saying that, Craig, that last part about the Supreme Court race, because something that I have found frustrating over the course of the last several Supreme Court races in Wisconsin is this sort of constant barragement of this person is going to keep your family safe, or I stand up for victims. And that's actually not totally the role of the Supreme Court, right? So we need our coalition partners, everyone out there who's an interest in just getting out the vote for the Supreme Court, to be really honest about what the Supreme Court does, what it doesn't do. And you know what? Sometimes when the law requires it, they might have to grant a new hearing to someone who did something that we all find reprehensible, but the law requires it, and that's the right thing to do.
Thank you. Could I just ask you to shout that last part about how these commercials have nothing to do with what they're going to be doing in the Supreme Court to the people in the back again, Michelle? Because it's a smokescreen. It's fake. They are using racist dog whistles to frighten people into voting against folks, implying that somehow this person is not representing what I'm going to say is the foundation of white supremacy, which is upholding everything that's broken in what the four of you have described.
Absolutely.
So I'm also not going to play cards with Elizabeth Pierson ever, because she brought up the gerrymandering again, and I was holding the 4 gerrymandering cards in my hand, and so it makes me suspect what kind of glasses she's wearing. But are there ways that the state Supreme Court can affect the unfair state of gerrymandering we have here? I mean, we talked about how Supreme Courts can revisit things when it seems to be in the interest of the individuals who have somehow uplifted a case to be in front of them. But redistricting was decided by the state Supreme Court, the U.S. Supreme Court. We've got all sorts of unfair maps, people designing maps, redesigning maps, throwing maps away. Like, what does this look like in the context of the state Supreme Court? Because certainly a lot of folks watching us online, watching across the state, and also writing here, and be thankful I was a public school teacher in Brooklyn, because I can read your bad handwriting. I have questions about this.
Yeah, well, again, it all starts with a lawsuit, and I think it's safe to say that if the court flips in a way that it seems more amenable to a gerrymandering lawsuit, one will be brought, and that has the potential to have them revisit some of this bad precedent, this least changes idea, and look again at the maps and at how we want our government to work based on just fundamental democratic principles and fairness. What is the best, fairest reading of our Wisconsin Constitution, which tells us that we're all supposed to be equal citizens and our votes are supposed to matter and our government is supposed to derive its power from the just consent of the governed. I think those are principles that could really inform a thoughtful court's revisiting of the rules for the maps.
Yeah, it's our only hope between now and 2030, really, to get better maps here in Wisconsin. If we can get a better court that is more amenable to saying the current maps are preventing people in Wisconsin from having an equal voice. We're not having fair representation with these rigged maps.
Thank you. So it is possible that a case could be brought, and then that what's the process for that actually getting in front of the state Supreme Court? Is that a potential reality?
Oh, yeah.
Okay,
Oh, yeah.
good to know.
That's going to happen.
Just wanted to say that louder to everybody in the back. And a couple of other questions that I've sorted out. There's another question here about whether or not this can face the court. One focusing specifically on Milwaukee County, how much Milwaukee County pays an unfair percentage of state funding that's taken then from our county, which then prevents us from providing services, alleviating poverty. And it seems that this is then determined by the legislature. Is there any way that the Supreme Court can weigh in on how the legislature chooses to help themselves to what should be in the pockets of Milwaukee County residents and make sure that it's redistributed equally back to this county?
Civil litigation related to the shared revenue formula. That's a little out of my area of expertise, but that's the setup, right?
But I guess, yeah, back to the Schoolhouse Rock, this would all start with a lawsuit. So anytime the Supreme Court of the state would weigh in, so to speak, on an issue, would be for someone or an entity or organization to file a lawsuit. And then if that is something that is significant enough, or it's an open question of law, or just sort of a hot issue that is very likely to get to the Supreme Court, it would get there. They don't take every single case, though, that they get petitioned to take. So sort of going back to talking about activists, right? They are very selective about the types of laws they want to challenge, the timing, who the plaintiffs might be, all with an eye to get that case before the Wisconsin Supreme Court to hopefully persuade them in whatever way their interests lie.
I mean, I will tell you one thing. I mean, in terms of the shared revenue formula and as it relates to, Milwaukee County and services, straight up, who's defunding police and other services in cities like Milwaukee? The Republican-controlled legislature. I mean, there's just no doubt about it. I mean, you squeeze the revenue of a city so that the only, formula we have for raising revenue is the property tax model. You deny Milwaukee, city of and county of, the ability to raise revenue through a sales tax, and then you reduce the share of money that you're giving them. And what do you have to do at the city level is make very tough choices about where to provide services, including police services. And then, for the other side, to look at the progressive side and cities like Milwaukee and say, you are the woke liberals that are defunding police is galling. It's ridiculous. That's coming from one side, and it's the right, not the left.
And then they put out ads about how dangerous Milwaukee is and why you need to elect there.
Right. Yes, because
they're tough on
the scary
crime.
people from Milwaukee are going to come and burglarize your home unless you vote for a conservative justice. Yes, that's right.
That seems like an incredible amount of power that the state Supreme Court has to police the other 71 counties in the state. I'm impressed. So one last question before we jump into some of these things. Actually, before we jump into the final question, this is the penultimate question, and it's a quick one. Based on some of what you responded earlier to a question, is it possible, and how would it be possible, and is it advantageous for us to move these nonpartisan Supreme Court election dates from April to the more partisan elections to get a more robust turnout? And if it is advisable in your opinions, what would it entail to be able to move that election date so that we actually do see more voters?
Well, I think it's advantageous. I mean, anything that gets more voters voting in our democracy is a good thing.
Yep.
So I'd be for that. It would require a change in the law, and so the legislature would have to pass a bill, and the governor would have to sign it. So.
Good to know. So now for the ultimate question, and I don't mean it in that connotation. I'm very grateful to the four of you participating on this panel. I really feel like you provided a masterclass in not only understanding the specific answers to these questions, but kind of helping to frame for all of us watching here what all of these incredibly large forces are that manipulate, that play into, and also helping us to narrow our understanding of what the Supreme Court actually does. Because besides the low turnout, a lot of us don't know what it is, right? And the court system can be very complex to a layperson looking in from the outside. side, not being taught what these things are in primary school and secondary school or in college, and then just not having time as we struggle to work in educating ourselves to this. So thank you. I'm hoping that each of you, now we go back to the 90-second rule, will take 90 seconds to explain to the viewers and guests why maybe you personally or institutionally believe it's so important for them to vote in the upcoming state Supreme Court election, and how maybe we as lay people can stay vigilant to these things that are relevant to the state Supreme Court, so that we can see past racist dog whistles and prestidigitalis, so that we know what is relevant really to the state Supreme Court for February and April. Answer all that in 90 seconds. I challenge you.
Get the timer out. So, I mean, what's at stake is our freedom, really. Is our freedom going to expand, or is our freedom going to shrink? And let me just put this in context. There is a larger, broader anti-democracy movement in this state and in this country. And we need to defeat that movement. And we need to vote, and we need to protest. But the opportunity to vote right now is right upon us. So please vote on February 21st, or vote next week before, and then vote on April 4th. But look, if you want to defeat gerrymandering, if you want to defend voting rights, if you want to defend abortion rights, if you're worried about what's going to happen in 2024, if there's a dispute in the elections for president, really urgent for us to go out and vote and defend our freedoms. The opportunity to vote in these Wisconsin Supreme Court races is an opportunity for you to choose the person who best represents you and your values. And it's the one time when you're filling out your ballot, when you have as much power as Diane Hendricks and Richard Eline and the richest person in the state, or the richest person in the country who may not even be in the state, telling you how to vote. So use that power, use your voice. Make sure you vote in this primary. How'd I do?
Pretty good. Set the bar high.
I'll start with how can we keep an eye on the court and hold them accountable, because I think it's very true. A lot of people just don't really understand what they're doing, and it can feel very mysterious. So just on a very basic level, if you can get to Madison, you can watch Supreme Court arguments. They are open to the public. It is your state house. You can go in that room and watch them do their thing. You can also watch it online on Wisconsin Eye. I think that's worth doing if you have the time and if it's a case that's interesting, because it just really highlights that these are just people and they have values and they have perspectives, and those often shine through. So that's one way to sort of just get a sense of who they are and what they're doing. And of course, we do get to vote for our Supreme Court justices and other judges, and they do work for us. So it's really important to understand what they're doing and to keep voting every time they're on the ballot. This panel has shown, as I'm sure everyone here already knew, that our Supreme Court has a lot of power, and a lot of the most important cases are decided by just one vote. So every seat on the court matters a lot, and every vote matters. And because we, and especially I, have talked a lot about the gerrymander today, I just want to be super clear that for statewide offices, the gerrymander can't touch it. So, in this election, your vote really does count the same as everyone else in the state. I think it's gotten kind of hard to dream big as progressives in Wisconsin. We've been sort of hemmed in on all sides. And last year, as we've discussed, the court did spend a lot of its time undermining our democracy. But a different group of justices could act very differently. It could do a lot of good in areas related to election law, voting rights, the balance of powers, environment, bodily autonomy, public education. So we have an opportunity right now to really make a change and think about how our court should serve us and what our state constitution should mean. So everyone has the right to vote for the Wisconsin Supreme Court, and it's really important that we all exercise that.
We talked about Trump versus Wisconsin, and there was another co-occurring case in the federal court level, Trump versus Wisconsin Election Commission. And at the Supreme Court level in the state of Wisconsin, you mentioned that it was decided by a 4-3 vote, with really one justice on the conservative side, Justice Hagedorn, deciding with the progressive side, one vote away from tossing our votes. I try, at my age, not to sound like I'm in an like a progressive echo chamber, or to be overly dramatic. But when progressives said preceding the last national election and now heading into this one, that democracy is on the ballot, that, you know, the way that we operate in our country, you know, with a constitutional democracy is on the ballot. It's not being overly dramatic. Okay, I mean, at the federal level, you know, former President Trump's challenge to Wisconsin election results were turned back by a single judge who was a Trump appointee. And if you read that opinion by Judge Ludwig here in the Eastern District of Wisconsin, he begins his opinion saying this is an extraordinary case. And as I was reading it, I was realizing why he was saying that. As he noted, never in the history of our country had a presidential candidate from one of the major two political parties asked that a state's election results be thrown out. I thought, wow, that does put it in perspective, right? This is an extraordinary case, and that judge did the right thing and turned back baseless challenges to our elections in Wisconsin. Now, everything flows from the ability to have representation in our democracy. Criminal justice issues, regulatory issues, reproductive rights issues, everything flows from that. And so, I think that in a world where there's two sources of power, money and people, voting is people power, and so far we've been holding back attacks at our democracy, holding them at bay, but they're at the door and they're barking and they're trying to get in. And so I think everything's at stake personally.
Well, I don't really have a whole lot to add after the three other panelists just spoke. I wholeheartedly agree with everything they said. I guess my message would be to vote your values on February 21st and on April 24th. To think about yourself, your family, your loved one, your neighbors, and everything that is at stake for everybody you care about in your lives. I'm not trying to be over dramatic, but I agree with Craig. I think it's all on the line. These cases have just the tremendous impact that one single case can have in this state cannot be overstated. These cases are often decided on a 4-3, right now the majority leaning conservative. And it doesn't mean we know exactly how the new justice will come down on every single case, but if we know their values and they align with ours, we know we have a much better chance at saving our democracy in this state than without that justice. So go vote, encourage people around you to go vote, make a plan, help people out, give them a ride, whatever it takes. There are a lot of organizations that also help, with, I think Souls to the Polls does rides for people who need it. If there are problems, because there are sometimes problems at the polls, make sure those get reported. There are election inspectors because, as Elizabeth said, in the statewide election, gerrymandering won't affect the outcome because everybody's vote will count. So make sure problems are reported and just get out there. Thank you.
Thank you so much. Again, Michelle, Craig, Elizabeth, Matt, thank you so much. And friends, thank you for joining us. We really hope you enjoyed our first hybrid Phillips Forum. Now I can officially stop sweating. Nothing fell down, no electricity. We'd also like to invite you all to join us for our next virtual forum, which is we are co-sponsoring with University of Wisconsin-Milwaukee Center for 21st Century Studies. It's called Trust in Context, a roundtable conversation about the histories that inform food and land justice efforts today. That'll be Thursday, February 23rd at 1 p.m. That's part of a 3-part series, and you can register and learn more at the QR code at your program. We'd also like to remind you to vote in the upcoming primary election on Tuesday, February 21st, and the spring election on Tuesday, April 4th. You can check your registration status, find your polling place, and et cetera at myvote.wi.gov. There are also, we're going to be having, as part of the Building Unity statewide push to get us all involved in democracy. There are going to be forums constantly, so take a look at Wisconsin Voices, at Building Unity, at our Facebook and web pages, and you can find out where they're going to be. Racine is the next one. And again, I'd like to thank our guests here at Turner Hall and on our live stream, our production team, Cheston Van Huss, and the great folks who co-sponsor the Milwaukee Turner Phillips Forum, which includes Wisconsin Voices, the Building Unity Coalition, the NAACP Expo, Marquette University Center for Urban Research and Teaching and Outreach, the American Constitution Society, Rid Racism Milwaukee, MICA, the National Lawyers Guild Milwaukee, and DeRoot Consulting Cooperative, along with the statewide coalition of over 40 groups. If you're interested in supporting us, the Milwaukee Turners, visit our Facebook or visit our website. Pretty easy. It's milwaukeeturners.org. And you can also learn on our website how to become a sponsor of the Phillips Forum and see our previous episodes. It smells delicious. It's torture to be up here. I can't wait to leave from my seat and go have some brisket. I invite you all to go next door, have beer and brisket. Until next time, everybody, please take care of one another.